I turned onto my street and saw the excavator before I saw my house. Its arm was already swinging. Wood splintered in slow, deliberate bursts, like rifle cracks carried on morning air. For a moment, I thought I had the wrong address. Half my roof was gone. Yellow tape stretched across my driveway. A laminated HOA notice flapped against a temporary fence. No city seal, no court order. Just a board authorization citing immediate corrective action. One of the board members stood near the curb, hands folded like he was supervising landscaping. When he saw me, he didn't look surprised. "You were warned?" he said. I didn't raise my voice. I just listened to the sound of my porch collapsing. The American flag was still mounted beside the door when the excavator clipped it. The pole bent. The flag fell with the siding. Strange part? I had already complied with every notice they'd ever sent. I spent 22 years in the Army. Infantry first, then logistics command, once my knees started reminding me. I wasn't 20 anymore. I deployed 4 times. I learned how to move people and equipment across continents without losing track of a single crate. In the military, paper trails matter. Chain of command matters. You don't act without authority, and you don't confuse rank with righteousness. When I retired, I wasn't looking for excitement. I'd had enough of that. I wanted quiet. A stable address. A place where the loudest sound at night was sprinklers ticking across grass. I bought the lot with savings and built the house deliberately. No mortgage, no shortcuts. Every permit pulled. Every inspection passed. I kept a binder with copies of everything: permits, approvals, receipts filed by date. The day my retirement orders became official, I planted a red maple in the front yard. Dug the hole myself. That tree was supposed to outlive me. The first letter from the HOA arrived 6 months later. It looked routine. It wasn't. The HOA president introduced herself to me the week after that first letter arrived. Polished handshake. Direct eye contact. The kind of smile that never quite reaches the eyes. She spoke carefully, like someone who understood the weight of phrasing. "We're committed to maintaining community standards," she said. "Consistency protects everyone." The first citation mentioned aesthetic inconsistencies. My fence stain was apparently a shade too dark, even though it matched the sample approved by the architectural committee 2 years earlier. I sent a copy of the approval. Next came landscaping violations. Then a notice claiming I'd modified exterior features without review. I hadn't. The patio extension she referenced had written authorization on HOA letterhead. I sent that too. At the following board meeting, she addressed the room, not me. "We have to protect property values," she said evenly. "Standards exist for a reason." Several neighbors glanced in my direction. I responded with dates, signatures, documented approvals. She responded with tone, with implication. And then the violations started arriving faster than procedure allowed. The letters stopped looking routine. Daily fines began accumulating for continuing non-compliance. $50, then $100, then retroactive penalties added without explanation. A demand letter from the HOA's attorney followed, formal and sterile, alleging unauthorized exterior alterations and structural irregularities. Structural. I had architectural approval dated 5 years earlier for every modification referenced. I mailed copies by certified mail, return receipt requested. I highlighted signatures. I included timestamps from the county permit office. I kept a log of every delivery confirmation. They didn't respond to the documents. They escalated the language. The president sent notice of emergency corrective action authority under the bylaws. I reviewed the bylaws line by line. Emergency action required independent verification of safety risk and majority board consent. I requested internal review and mediation, as permitted under Section 8.4. My request was acknowledged, then quietly tabled. Fines continued accruing during the delay. That was the part that didn't fit. If this was truly about compliance, mediation would have resolved it. Instead, another letter arrived. Immediate remediation authorization. The excavator operator kept working while I stood at the edge of my driveway. No city trucks. No building inspector. Just a private demolition contractor with 2 laborers and a portable dumpster. I asked to see the order authorizing the work. The foreman handed me a packet clipped at the corner, HOA letterhead, a board signature, language citing immediate structural hazard requiring removal. No court seal, no municipal citation. I called the police anyway. An officer arrived, listened, reviewed the paperwork, and handed it back to me. "This appears to be a civil matter," he said. "You'll need to resolve it through the courts." Through the courts. 2 months earlier, I had paid for a licensed structural engineer to inspect the property after the first accusation surfaced. The report was clean, no load-bearing compromise, no safety risk. I kept that report in my binder. I didn't argue with the crew. I stepped back and started documenting. I filmed the equipment serial numbers, the contractor's license plate, the permit number taped inside the cab window. I captured timestamps, wide angles, close-ups. By late afternoon, sunlight passed straight through what used to be my living room. By sunset, half my home was gone. That night, I began drafting a formal records demand under state property law. State law gives homeowners the right to inspect association records. It's not optional, it's statutory. I submitted my written request the morning after the demolition. The management company replied that documents would be available within a reasonable time. Reasonable, stretched into weeks. So I had a friend, an attorney I served with years ago, send a formal demand citing the exact statute and penalties for noncompliance. That changed the tone. 3 days later, I was given a 2-hour window in a conference room with a banker's box of records. I didn't rush. I photographed everything. There was no independent engineering report authorizing demolition. No municipal citation. No emergency city notice. The board minutes from the week prior contained no vote approving structural removal. Instead, there was a printed email from the HOA president stating she had determined immediate risk and was exercising emergency authority. She had determined. Then I found the insurance correspondence. The carrier had explicitly warned that demolition without verified hazard assessment and full board approval could void coverage and expose directors to personal liability. One more document sat clipped to the back of the minutes. A written objection from another board member. It questioned both the urgency and the optics, voting, node, potential discrimination exposure if enforcement appears selective. That objection had been acknowledged and ignored. The demolition wasn't just aggressive enforcement, it was unauthorized. And unauthorized decisions create liability that fines never could. Once I had the records, I stopped attending meetings. I stopped responding to letters. There was nothing left to debate. I retained counsel and filed suit in state court. Wrongful demolition, trespass to property, breach of fiduciary duty, and violation of federal housing protections. The complaint was precise. Dates, documents, attachments, no adjectives. The board was served on a Tuesday afternoon. Through discovery, we subpoenaed the demolition contractor's communications. The invoice showed expedited authorization. Payment approved the same morning. The equipment arrived, personally authorized by the HOA president, not the board treasurer. There was no engineering addendum attached, no emergency rider. Then the insurance carrier issued its position letter. Coverage denied due to procedural violations and unauthorized executive action. Defense costs would not be indemnified. That meant the board members were now exposed individually. I didn't comment publicly. When neighbors asked questions, I told them it was in litigation. My voice stayed even. My posture stayed relaxed. Paperwork does what arguments can't. The deposition was scheduled for early spring. That's where her certainty began to fracture. The deposition took place in a neutral conference room downtown. No raised voices, no spectators. Just a court reporter, 2 attorneys, and the HOA president seated across from me. Under oath, she stated there had been credible evidence of structural danger. My attorney slid a copy of the licensed engineer's report across the table. Dated 2 months before demolition. Clean findings. No hazard. She paused longer than she meant to. She then testified that the board had approved emergency action. We marked the meeting minutes as an exhibit. No vote recorded. No motion carried. Only her email asserting unilateral determination. When asked about her authority under the bylaws, she cited a clause allowing temporary safety measures. My attorney read the full section into the record. It required independent verification and majority consent. Neither existed. The shift was subtle but visible. Shoulders tightening. Answers narrowing. Qualifiers creeping into statements that had sounded confident minutes earlier. Other board members, deposed separately, began emphasizing that they relied on her representations. When it was my turn to speak, I explained why I built that house. After 22 years overseas, I wanted quiet. I wanted permanence, not conflict. 2 weeks later, the judge set deadlines for summary judgment motions. The paper war was entering open court. The court granted partial summary judgment on liability. The demolition was ruled unlawful. The judge found the board had exceeded its authority and breached its fiduciary duty. Evidence of selective enforcement and internal warnings was sufficient to let the discrimination claims proceed to a jury. The damages phase took months. Experts testified about rebuild costs, lost property value, displacement expenses, and the non-economic impact of losing a primary residence under unlawful action. The jury deliberated 2 days. They returned a verdict totaling $12 million compensatory damages to fully rebuild, damages for emotional harm, and punitive damages tied to reckless governance. It wasn't a windfall. It was accountability measured in dollars because that's the language civil courts use. Before final judgment was entered, the HOA president submitted her resignation. But the money wasn't the real outcome. Reconstruction started that fall. I kept the original footprint, but reinforced everything: steel connectors, upgraded framing, higher wind rating, quiet improvements. The red maple in the yard had survived the machinery. Its trunk was scarred, but it was standing. I didn't sell. I didn't relocate. I moved back in when the final inspection cleared. The first HOA meeting after judgment was subdued. A new board sat at the table. Revised bylaws were introduced. Supermajority votes required for enforcement actions. Mandatory third-party inspections before any structural claim. Full membership notice before emergency measures. I listened. I didn't speak. I hadn't filed suit for revenge. I filed it to correct a record and prevent it from happening again. When I walk up my driveway now, I don't wonder if I belong. Belonging isn't granted by a board vote. It was earned long before I ever bought that land.